I appreciated the invitation to come speak about this topic, which is so critical now, and really we are so dependent on the security professional. I was a double major in French and English literature, and I know what the laws are, and I know what the fairness principles are, but I don't understand all the tech. So the greatest thing that we need from y'all is really just a basic understanding of some of the underlying and core principles, and then to really explain to us how the tech works, and not just how it works now, but what the capabilities are for the tech. So this is just a quick bit of information about me. I'm a cybersecurity and privacy lawyer in Birmingham. I work remotely. Most of my clients are out of state. I do a lot of GDPR, so European work, a lot of CCPA, California work, so a lot of compliance-oriented work, but I also do a fair number of complex tech transactions. My contact information is there, and again at the end, so feel free if you have any questions to let me know. So basically, I was invited here to sort of talk about why now. Why is privacy exploding? And we've seen the convergence of several different factors. One is just the continuing series of really creepy big tech scandals. And we'll hit the high points of some of them. Y'all are probably familiar with some of them. They've been very well publicized. But you'll see the common thread is something really kind of just gross or icky that they did that makes consumers uncomfortable, which consequently has prompted greater consumer awareness of big data and how that's used. And so one thing that we lay people have become aware of in the past 6 or so months is the vast secondary data market. IBM said last year that 90% of all consumer data in the world was collected in the preceding 2 years. So there's really a learning curve for all of us about who is collecting our data and why. At the same time, our friends in Europe have passed the General Data Protection Regulation, or GDPR, which was effective a year ago, the end of May. And so that has impacted directly and indirectly a lot of our larger companies, and has also brought greater awareness to our citizens about, okay, so how is ours different? What do we need to be focusing on that we're not focusing on? And then finally, we're seeing a greater need for consumer engagement with some of this tech. A lot of the press has been about passive data collection, your online activity, your geolocation activity as you walk around with your phone, IoT security and privacy issues. But the next phase really is going to require more direct consumer engagement, like smart cities tech. So consumer buy-in and trust is becoming more critical, and privacy is a huge component of that. So again, just sort of to hit the high points about why we're all excited about privacy now, and what has led to the current consumer alarm. And I mentioned at the beginning of the talk my lack of facility with the more complicated tech. And I think as consumers have become more and more aware of what's happening, of what facial recognition is and does, and what its capabilities are, what biometric authentication can do, there is, at the same time, there is increasing consumer alarm about the ways in which big tech and big data have arguably failed us on the privacy side. There's also an increasing alarm about how complicated the tech is getting, and the layperson's difficulties in really understanding what the tech is doing. So it's sort of worthwhile to just touch on briefly the difference between security concerns and privacy concerns, because it sort of forms the background for this talk. Consumers historically have been concerned about the safety of their information, right? They've conflated privacy and security, and it's really just been in the past 18 to 24 months that there's been an understanding that privacy is distinct from security. Your cybersecurity can be working 110%, your IT people and your IS people fully engaged, but if the people who are setting making the privacy decisions, setting the privacy framework for your organizations, the ones who are deciding which data is more valuable. That really informs what data is collected and how that data is ultimately treated. We all have multiple old Dells in our closet that have, our Disney vacation from 2004. Well, maybe you all don't, but those of us who have not been keeping up with our photos online, we just save them and put them in the back. A lot of organizations have been doing that, and a lot of the even smaller and medium-sized businesses that are very on top of their cybersecurity often forget about legacy systems, old employee information, old customer information. So we see sort of a disconnect between the focus of privacy and the focus of security. And one recent event that really highlighted that was the FEMA breach. That became publicized, I think, in early June, but it's been ongoing for at least a year, and they say it will be June 2020 before it's fully remediated. But the problem that FEMA experienced is it went through the exercise of looking at all of its government contractors and what personal information they were getting of disaster victims, in an effort to consolidate and to sort of weed out unnecessary sharing of personal data. And so they came to an agreement with a government contractor that provided transitional housing assistance that they would start sending 20 fewer data points, including social security number and other highly sensitive information that the government contractor didn't need. And we're not sure exactly what happened in the disconnect, but it may have been that the people making the handshake and amending the documents did not communicate with the tech people, either to find out how hard that would be to implement or to let them know it needed to be implemented. So for a considerable period of time, those 20 data items were continually fed to this government contractor, which apparently didn't realize they were receiving them. So that's 100% a privacy failure. That is an internal policy failure, and that's independent of information security and cybersecurity. I'm starting with a couple of older scandals because they sort of triggered the recent onslaught of media attention. Among many other scandals, Uber has experienced at least 2 large privacy scandals. At the time of this scandal, they were already under a consent order with the FTC for their use of GodView, which was what they referred to their technology that tracked all drivers and riders in real time, without regard to whether or not you were using the app or had used it in a year. And that what the Uber employees were doing is they were tracking in real time the movement and monitoring the movement of journalists who had published unfavorable articles and media accounts about other unrelated scandals that the company was facing. So that got them into hot water with the FTC, and while they were still negotiating that consent order, there was apparently a hack on Uber systems, which was not very sophisticated. I think it was due to lack of patching or some sort of upgrading that should have been pretty rudimentary. But at that time, they didn't have a privacy officer. They had the CEO, who at that time was the founder, the head of information security, and then a guy from the legal department. And their immediate concern, of course, was you contain the incident, right? So they cut off the flow of information. And then the head of IS went and found the 2 guys, literally 2 guys, who had committed the hack, and got the 2 guys to tell them they hadn't used or shared the information. So they paid these guys $250,000 to sign non-disclosure agreements saying that they wouldn't tell anyone about the hack. So it was the ensuing cover-up rather than the hack itself that really set off alarm bells among regulators and the media and consumers. It really got the attention of the state AGs last fall. The attorneys generals of all the states settled for $148 million with Uber, primarily based on the cover-up. And then, of course, that brings us to Cambridge Analytica. I'm sure you all have a fairly high degree of familiarity with that. We were all probably involved at some point or the other, but it was like one of those Facebook personality quizzes, but on steroids. There was an academic in England who was trying to develop better ways of assessing personality, so it was a very in-depth personality quiz, and the people consented to participate. So it was a voluntary, you weren't just doing that Google face match, which we all now know was a facial recognition exercise, but you consented to the disclosure of this information to the academic. And Facebook at that time had developer terms. They didn't require all their developers to sign specific contracts, but the developer terms clearly said you can't use or sell the information for any other purpose. The problem was they didn't monitor that. And as the Cambridge Analytica scandal broke, it became apparent that Facebook wasn't monitoring any of these application developers. So it became a much bigger problem. But the initial incident involved 300,000 Facebook users who opted into this game or quiz. But the information was used to leverage profile information of up to 87 million Facebook users. And then what the academic did was sell that information to Cambridge Analytica, which was, for lack of a better word, a lobbying firm that used that data coupled with data obtained from other sources to generate highly specific and selective profiles of voters all over the world. So this is the creepiness factor. They used very specific data about individuals culled from a variety of sources, including all this personality quiz information and the leveraged profile information, to decide how to market a candidate or campaign. And this was used in the 2016 presidential election, in Brexit, in the Mexican election. So it's a worldwide problem. And the concerns here, of course, was that the collection of the information exceeded the purpose. Apparently, more information was collected than was needed to conduct the academic research. The use and disclosure of the information exceeded the consent, and the overwhelming majority of the 87 million users were not aware and did not even know that this was happening, much less consent. So Facebook went in front of Congress, and Congress said to Facebook, we want you to tell us where all the Facebook user data is. And they came back several months later with a 740-some page report that basically said we couldn't get in touch with about 2/3 of the app developers because most of them were out of business and the others wouldn't return our phone calls. So it's been sort of a Pandora's box of information that is really just gone. After that, it came out that Google Plus's API had what they called a software glitch because, of course, they always blame the tech guys. Of course they do. But that was exposing private profile and account information of Google Plus users. And even those of us who never signed up for Google Plus, if you had a Gmail account at the time, apparently you had a Google Plus account. So this information was just exposed to developers on the internet. Now the creepy factor here is that Google discovered the problem and fixed it, but realized the problem had been going on for several years, and they made an internal decision not to disclose it. Once it became public, they said that there was no evidence of misuse by third parties, and that just makes me sweat more because it just means they hadn't found it yet, or they're not going to find it. But it's really hard to say with years of exposure of millions of people's personal data points to hundreds of thousands, if not millions of developers, that there was no misuse. But they decided there was no consumer harm, and one of their justifications was that the developers and users couldn't do anything about it. And they couldn't identify the users whose information had been exposed, although apparently it was maybe everyone. So the concern there was excessive collection of information and the lack of transparency by Google. They had internal memos where there was expressed executive concern that due to Cambridge Analytica, that disclosure of this might trigger unwanted regulatory scrutiny, which is also not an affirmative defense to one of these cases. But again, it was a bad situation handled worse. There have been a variety of privacy scandals since. It came out in further investigations of Facebook that when you linked your Facebook account to your contacts for the purpose of finding your contacts who are on Facebook, they uploaded all of your contact information and kept it, and then used it to match with other existing Facebook profiles and other information gained from other third parties to sell advertising. It also came out last summer that several of the large free email service providers were actively scanning email contents to help target advertising and for other purposes, and that in fact many employees or real people were actually viewing and reading these emails. Location tracking has really touched a nerve because people didn't realize how much their location was being tracked and by whom, and whom had access to that. But it became apparent that all of these commands that we have on our phones and in our apps saying turning off location services really were not effective, right? Because you have satellites, you have GPS, you have your operating system that's tracking you, you have individual apps that are tracking you. If you're in a store, some of these larger retailers, they track you by light and sound so that they can present to you a coupon on your phone if you're standing near the jeans aisle. I mean, there was just really no understanding of how widespread this location tracking was, but again, it touched a nerve. It touched a nerve in individuals. Last November, privacy became the lead story on 60 Minutes, and really the big story there was several years ago, Big Tech testified before Congress and convinced Congress that regulation was inappropriate at that time because the regulators didn't understand the tech. Regulation would stifle innovation, and who better to self-regulate than the tech companies because they knew how it worked. So a lot of what we're facing now is just a general, people are down on big tech, but unfortunately, that sweeps everyone under the net. So we've seen sort of a distinction between privacy and cybersecurity. There's been a lot of data breach fatigue. Privacy scandals are still current enough. There's historically been this conflation of these concepts of privacy and security as a safety. And then this confusion and this mistrust breeds a lot of anxieties on the part of the consumer. And so the key questions for any privacy professional, and you'll see that you'll get asked these over and over again with respect to data, is who, what, where, why, how, who. Whom are you collecting data from? What kind of data are you collecting? Where? How are you getting it? Why? What is the purpose for the collection? And how are you collecting it also? So this brings us to the fair information principles, which have been around since I think the 1950s and are actually an international concept, but they form the underpinning for the GDPR and the CCPA and the data protection laws of most other nations, and are also forming the backbone for legislation that states are looking at adopting. But it's pretty rudimentary stuff, right? Collection limitation, limiting the collection of data to what you actually need. That goes hand in hand with purpose specification, openness and transparency. Are you telling people that you're collecting their information and why? That's purpose specification. Are you limiting the collection? Then are you securing the data you're collecting? Are you making sure that the data you're collecting is relevant and accurate? And then do consumers know what you're collecting, and do they have any redress or access? So the GDPR and the CCPA really have as the cornerstone certain access rights by individuals to understand what data you're collecting and how you're using it, and to stop you from certain types of data sharing. And accountability, of course, goes to how you show that you're demonstrating, how do you demonstrate compliance with the other principles. And what we're seeing first with GDPR and now with CCPA, is that if you don't have privacy by design, which most companies don't, it's really hard to go back and try to instill these principles retroactively. And if you want just a little real-life experience with that, ask your company what cookies they use, because very few companies actually know. It is really critical then for the security folks and the tech folks and the developers to understand the privacy concerns of your organization. So this is just sort of this is about a semester, maybe a year in law school. So I'm not going to walk you through it, but the bottom line is that personal data is very unevenly regulated in this country and tends to be regulated sectorally. Financial institution information, electronic protected health information. So we don't have a comprehensive data regulation like the GDPR or Brazil or Canada. So we have a patchwork of different federal laws and state laws. So absent legal guidance on how you try to conform to privacy principles, there's really been a lot of encouragement around looking to what existing law there is and looking at the fair information principles and trying to incorporate those in process development of new tech, implementation of new tech, establishment of new vendor relationships. So the GDPR, privacy in the European Union has always been a constitutional right since the 1800s. It's considered a fundamental human right. And that is in contrast to what we have here, which is just a different perspective. But GDPR, this slide just shows the accountability measures. That's how you demonstrate compliance. This is not the full litany of substantive requirements and limitations, but it sort of gives you a good overview of what the more critical requirements are of GDPR. And you can see that they're organized around the fairness information principles, the ideas of transparency, data portability, objection to certain types of data usage, access, correction and erasure, restriction of use, and then of course accountability. The CCPA is often referred to as our domestic GDPR. It's not quite the same. Yes, if you're GDPR compliant, you're much farther ahead in CCPA compliance. But if you look at the accountability areas, and again, this slide is just directed at accountability, you can see sort of the high points. There are some very substantive differences that need to be accounted for. But again, this is a law and regulation that is really centered on and focused on the fair information principles. And the fair information principles that are relevant under CCPA are the same ones that are relevant under GDPR. So how does this impact business? There are a lot of businesses still in this country who are not directly subject to GDPR and will not be subject to the CCPA. But we have seen through the Facebook and Google and Uber and some of the other scandals that adverse reputational impact can lead to market value reduction, can lead to a disruption of innovation, and that goes to the mistrust factor. Several months after Cambridge Analytica was exposed and the further developments were reported in the press, it also came out that Facebook had approached the top 5 or 10 banks in this country to partner with them to offer online banking through Facebook. And 201, they all said no thank you. Because if you're mired in a bunch of privacy concerns, it's harder to partner with companies who care about privacy and care about their reputation. Also, they're just, as you can see from these scandals, they're really ticking everybody off. And they may be ticking journalists and consumers off, but they're really ticking off regulators, legislators. That's how we got the CCPA, and judges, as these cases wend their way through the judicial system. And there are multiple cases against Facebook pending class actions. A A judge in a Facebook data breach case said in open court that the discovery would be bone-crushing, which is really a huge thing for a judge to say, and puts all companies on notice that you've got to be taking care of your cybersecurity and your privacy equally. I think it was last Friday, the district court for DC declined to decertify a class action in connection with Cambridge Analytica, which is going to lead to a lot of discovery, a lot of more revelations about Facebook's practices, and that's just in the DC circuit, and there are these cases nationwide. So we've got uncertainty in legal guidance, and we've got, there's a consensus or a stream of thought that we're really, privacy legislation and regulation is imminent. Last fall, I really thought federal legislation was imminent. Now I'm not so sure. We're seeing more activity at the state level, although the states tend to be more patchwork. I do want to mention UDAP, and that has been mentioned on several preceding slides, but that's the prohibition against unfair and deceptive trade acts and practices generally. It applies at the federal level through the Federal Trade Commission Act. It's Section 5, and that's how the Federal Trade Commission gained its enforcement authority in this space, and every single state has one. They're consumer protection laws, and they don't reference privacy specifically, but they're engulfing the space as far as litigation is concerned. And so then you have to worry about what is unfair. You know, deceptive is easier. A lot of the earlier FTC enforcement actions were against companies whose privacy policies said, we absolutely do not do X, and then they did X. So again, a high creepiness factor, clear deception. It took about 5 to 10 years for the FTC to really focus on the unfairness part of it. And again, these tend to be very egregious cases. But what we're seeing at the state attorney general, emboldened by Uber, are really becoming more and more active in the privacy space under these UDAP laws. And so the concept of fairness is important, and that sort of loops back with these fair information principles. There are industry groups that have standards for developing privacy frameworks and privacy requirements. Those are helpful to refer to. More notably, NIST is developing a fairly substantive privacy framework as an adjunct to the RMF that will be incorporated in the RMF. And again, that will be helpful for organizations to assess and incorporate privacy by design. And NIST raised a good point, which is another theme of this talk, which is that good cybersecurity, excellent cybersecurity, doesn't solve all the problems and exposures, because privacy risks at their base arise from how companies collect, store, use, and share information. So that's the what, where, how, who, the 5 questions that privacy professionals will always ask you. So NIST's goal is to incorporate the privacy framework in the RMF to follow that sort of trajectory of being a voluntary guidance for organizations to use as appropriate, and to allow organizations to better manage privacy risks. There have been a lot of public discussions and forums and workshops on how to do this, and NIST has been very inviting of the privacy community to help build off of, this is the NIST RMF, to build off of these steps in a way that is natural, to add privacy to these steps and to incorporate them into how they're used. But there are some differences. I went to an all-day workshop in Atlanta a few weeks ago, and we spent an hour and a half in one workshop where basically 4 people argued about what 2 different words meant for an hour and a half. And I'm a lawyer and a wordsmith. So, ordinarily that might interest me, but it gave me really a sense of the challenge that NIST faces, because the concepts of privacy and security can be different. The standards are not nearly as specific. There's not a lot of real-world guidance at this point, but the NIST privacy, the new RMF version with privacy, is fairly imminent. They're trying to get it out as soon as they can, and I would encourage you all to consider using it. This slide shows a list of what NIST has announced are its guiding principles for the NIST RMF with privacy. And if you read these, you'll see that they really are the fair information principles. So again, we're seeing them cycle through all the legislation and privacy by design standards. ISO has an existing privacy standard regarding privacy framework and language generally. There's an ISO committee that is developing a privacy framework to incorporate privacy by design in the development of IoT. And so we also see privacy professionals turning towards security standards. You know, there's this concept of reasonableness and security that the FTC has developed through UDAP enforcement actions, and that we're also seeing a lot of the state level, the more recent state data breach notification statutes require reasonable security. There's a lot of questions about what that means, but we know it all means some level of security, and we're trending that way with privacy as well. And so again, just to sort of emphasize, again, the point that the tech innovation has been rapidly outstripping the laws, the understanding of the legislatures and the regulators, and consumer understanding and awareness for many, many years, and it's just all sort of hitting at the same time. You know, the focus has been on efficiencies of scale, personalizing the customer experience. There have been a lot of good reasons for the initial collection, but what has startled so many of us is just this huge explosion of the secondary data market. And again, I'll mention IBM. A few months ago, the media accounts erupted with this location tracking scandal by weather apps, and there were several involved, but the weather app was apparently the most egregious. And then I think even if you deleted that app from your phone, they somehow were still tracking you. But certainly, like the Uber God view, if you had used the app once and then closed it and never used it again, it was still tracking you, your geolocation, your physical location, in real time over years and years and years. And several years ago, IBM acquired the Weather Channel app. They did not acquire the Weather Channel. They didn't acquire any of the TV. They didn't acquire any of the technologies used in climatology and in weather forecasting. They acquired the Weather Channel app because they wanted that geolocation data. And they combined it with other data, and they sold it over and over and over again. And so it's this misunderstanding of how our data is being used and repurposed that has really caused concern. And so I think we're going to see more and more regulatory efforts, litigation efforts around these fair information principles. And we are seeing that consumers in this country thought that those principles already were applicable, when in fact they're not directly applicable in most cases. So what we as privacy professionals strive to do with our organization is to help manage and mitigate the risk of large-scale data collection so that it fits the objectives of the organization and so that we have openness and transparency. I work for a lot of financial institutions with our members, with our customers, because of course, you know, if you're a financial institution, your reputation is paramount, your customer relationships are paramount. And so what we've seen is that oddly is that so much of this MarTech, which was meant to increase and enhance customer experience, is really driving customers away from certain types of companies and technologies. And I don't mean to overstate that. You know, Facebook goes down and then it goes back up. But it is clear, I mean, the DOJ just announced they've divvied up the 4 big tech companies between them and the FTC to see who's going to focus on antitrust concerns. And we see a lot of dovetailing between antitrust and privacy. So we'll see definitely more activity, and it's going to impact smaller tech providers down the line and all companies that use that tech. So it's important to be aware of the concerns that are driving privacy. So as I said, we're looking to see greater consumer awareness, increased regulation, definitely increased class action litigation, more laws at the state and federal level, and then really this push through the NIST, RMF, and otherwise towards the concept of incorporating privacy by design. So this is just all the reasons why people are upset right now, sort of restating what I've stated, and to get to sort of the big purpose of the talk, which is I have found, and again, I said I was a double major in French and English literature, that the language of privacy professionals and the language of security professionals often differ. And so it's really important to have a collaborative approach so that we understand how our questions are being heard. I worked on a data breach, well, it was a potential data incident over a year ago where the client contacted me and they said we had 11,000 customer files viewed by an unauthorized party. Well, it took 7 or 8 meetings with the IS and the tech people to understand that the way the system worked, if you clicked on a folder that included thousands of documents, the system showed all the documents as opened. But when they went back and looked through the logs and tried to recreate what actually happened, it looked like someone was clicking through the folders, but never clicked on the specific files, including the customer information. So there was actually no data breach. So we had to have several conversations about what open meant, what access meant, what preview meant. And it's really been an education for me to sort of understand. And we think, a lot of us think differently. You know, we're more big picture, we're more if X then Y, if A then B. And the high level of technicality can be very intimidating. But I think we're going to see, and I hope we're going to see more and more collaboration among the functions as privacy by design becomes more common. So I'll take questions or wait around. If anyone wants copies of these slides, just send me an email. I'm happy to send them to you. Does anyone, and thank you, I kind of rushed through that because of my voice, but I appreciate your patience. I'm happy to take questions or stay after if you have one-on-one questions. All right, well, I sure do appreciate your time and your patience, and I'll stick around for a few minutes, so if you have any follow-up, just let me know.